Sterling and Chang Cheng.
Retrieve my book. Yes.
My Lords, may it please your Lordships. In this matter, I appear on behalf of the appellant, Mascareignes Sterling Company Limited, whom I shall refer to as MSC, and I appear with my learned friend, Mr. Maxime Sauzier, Senior Counsel of the Mauritian Bar. The respondents, Chang Cheng Esquares, whom I shall refer to as CCE, are represented by my learned friends Mr. Rebo, Senior Counsel of the Mauritian Bar, and Mr. Rebo, whom I shall not call Mr. Rebo Jr., but is indeed Mr. Rebo Jr. My Lords, I intend to introduce this matter to your Lordships and explain the course that we propose to take, including the division of labour, as it were, between myself and Monsieur Sauzier. I know, my Lords, that you will have read the cases of the appellants and the respondents, and therefore know that this appeal arises out of an arbitral award made now many years ago relating to the construction of an office building in Port Louis in Mauritius. A fundamental issue in that arbitration was whether the contract between the parties was of the nature of a lump sum contract or a measure and value contract, which is a matter addressed at some length in the appellant's case. And that had in the arbitration a significant impact on the way that the final account between the parties was assessed. Mascareignes MSC's position being that they had overpaid CCE. It was always MSC's position that the contract was a lump sum. In contrast, it was CCE's position that the contract was measure and value. They said, and the arbitrator agreed, that to construe the contract, one looked at the conduct of the parties in the performance of the contract, and that demonstrated that it was of a measure and value type. There was an alternative case that the contract had started life, so to speak, as a lump sum contract, but been varied by agreement. And those alternatives were reflected in the arbitrator's award, which dealt at some length with the argument as to whether the contract was lump sum or measure and value. And then in the arbitrator's conclusions, which are at paragraph 5.9.1 of the award, the page reference is 456.
Yes.
And your Lordships will see from that that the arbitrator's conclusion was that...
Yes, 5.29.1. If it wasn't the one, then it was the other.
Well, exactly. It was that, in his view, it was properly construed the one, i.e. measure and value, but if it hadn't started life as measure and value, it had become measure and value by performance.
There is then some very mysterious, at least to me at present, references to breach or fundamental breach,
yes,
which at the moment I don't understand, but if they're relevant, you can...
My Lord, with respect, I would agree that they are mysterious and somewhat incomprehensible, and I don't believe that they need to be addressed in this this appeal.
When I'm just looking at the structure of this case, your written case proposes that under Mauritian law, the courts can look at both law and fact, but the contract itself only provides for appeal on law. It doesn't say only on law, but one might have thought that that was the implication, since it provides for an appeal on law. So I think you're going to need to help us as you go through your submissions as to how far we are concerned with questions
of fact
and how far with questions of law. And you might also help us in that context with the question whether under the civil law, interpretation of a contract is a question of law or fact. We've actually got, courtesy of Lord Sumption, some assistance which you may or may not have been given a copy of. You haven't.
Don't believe we have.
We've got some. This is a book called.
This is Fleur, Aubert and Saveux. Droit civil, les obligations.
Both sides should have it.
You probably need that one.
Sorry, you should be given a copy.
Lord, may I address both of those matters in this way? As I said a moment ago, our position was that the contract was clear on its face that it was a lump sum contract. And it was important that it was, and still is important, that it was clear on its face that it was a lump sum contract. Because as a matter of Mauritian law, which would possibly not surprise your lordships, I'm not going to be dealing with, there was then no reason to look at the conduct of the parties as an aid to construction of the contract.
Was that in the written case, is that proposition?
Yes.
It is.
Yes,
it is. I mean, I think you can, again, we can perhaps cut to the chase. We're going to have to hear Mr. Rebo on this, but you can take very shortly the question, what was the nature of the contract at the outset? Because at the moment we have seen your submissions, we've read the contract, and we are prepared for the moment, subject to hearing Mr. Rebo, to proceed on the basis that this looks like and looks clearly like a lump sum contract. We may be persuaded the contrary at the outset, in which case the emphasis shifts to the alternative case.
Indeed. But, my Lord, I respectfully entirely agree, and indeed it goes slightly further than that, because it now appears that there has been a significant shift in the respondent's case in any event. Because if one looks at their case at paragraph 10.1, for which the reference is page 6147, if you want to use the bundle, the separate case, paragraph 10.1. 6147 is the...
Yeah, it's paragraph 10.1.
10.1,
yes. I noted that when I read it.
Yes, and that paragraph now appears to accept that there was a lump sum contract, but it makes the principal case now that it was varied or altered in the course of performance. So CC contends it was the common intention of the parties was to change and alter the contract they had signed from lump sum to measure and value. So that there is that shift, and it's...
Well, on that basis, I think, the starting point is that the arbitrator doesn't appear to have appreciated that.
Correct. And, my Lord, because that is now our starting point, it will perhaps come as no surprise to you that I'm very shortly going to sit down and hand over to Monsieur Sauzier to deal with the case as a matter of Mauritian law as to whether there is any basis for saying that the contract could have been altered in the manner in which CCE appear to argue. Can I simply, before I do that, take 2 points, or address 2 points. The first is the proposition in CCE's case that the arbitrator was exercising his power to rectify the contract in finding that it had become a measure and value contract. With respect, our submission is that that is completely misconceived.
Is that pursued in the respondent's case?
Yeah. It is indeed. It's paragraph 11 of the respondent's
means
case.
Giving effect to some prior agreement.
Indeed, indeed, my lord, exactly. So we say that's completely irrelevant. Their second limb of argument is based on Article 1156 of the Mauritian Civil Code. And as I said, that being a matter of Mauritian law, I intend to hand over to Monsieur Sauzier on that point, simply so that I have dealt with it it follows from that at least on this ground of appeal, this is fundamentally a matter of law rather than a matter of fact in the first instance as to whether conduct of the parties could alter or vary the contract in the way that is contended for. So far as the broader question...
Whether it did or not, you would accept this question of fact, is that right?
I'm sorry, my lord, I didn't hear the beginning of that.
I see your point that the question whether the contract is capable of being varied by conduct may be a question of law, but if the answer to that question is yes, the question whether it was varied by contract would be a question of fact.
Yes, my lord, I accept that.
And then the legal question for us would be, was there evidence which entitled the arbitrator to conclude that there was such a variation?
Indeed, and our position is that there was no such evidence, and although I am somewhat jumping ahead, the matters that are now relied upon by CCE in the respondent's case as evidencing such a change, 3 out of 4 of the matters were matters that were not relied upon before the arbitrator as evidencing such a variation to the terms of the contract, nor were they matters that were relied upon by the arbitrator. The only matter which finds voice in both the award and in the respondent's case is the payment of interim certificates, which is a matter we've dealt with.
There were 2 matters of respect. There was that and the absence of an architect, because the lump sum contract envisages a process of architect certificates which were not issued because there was no architect.
Yes, well, that's right, but the parties proceeded, that simply goes to the mechanism for payment by the issuing of interim certificates, not to the manner in which one assesses what is due for payment.
Well, I wonder about that.
Well, maybe a matter that I need to come back to, but that is the proposition.
Do you concede that we are not concerned with issues of law?
No, issues of fact. No, my lord, I don't. I don't for 2 reasons.
So we've got to face up to every issue of fact in the case that's still between the parties. Is that really the position?
Well, substantially, the appeal does not turn on matters of fact, but as Lord Sumption has identified, there are circumstances in which it may do. The position in relation to the grounds of, the arbitration clause is, I'm sure Lordships will understand the background to this. The contract was made using an English standard form of contract. And for that reason, there was written into the standard form of contract agreement to appeal on law, because that would have been necessary as a matter of English law, or one of the bases for an appeal on law, if the contract was subject to English law.
What is the juridical basis of the right of appeal in Mauritian law?
It is Article, I'm sorry, I'm going to have to ask Mr. Sozier to tell me, it's Article 1027, I'm so sorry.
Do we have that?
You should do.
Because, I mean, from my point of view, I would find it helpful as a starting point.
Indeed.
For any other matters.
Well, my lords, without wishing
what matters we are dealing with and what matters we are not.
My lords, without wishing to dodge the question, my answer to your lordship's question is that the proposition of Mauritian law, which I will ask Mr. Sozier to deal with, is that there is an unfettered right of appeal, unusually to English ears, an unfettered right of appeal from an arbitral award on both law and fact. That is not reflected as such in the terms of the contract because of the use of the English standard form, but against that background, the reference to an appeal on law is not to be construed as a limiting reference, but merely a statement of what is in any event the position under Mauritian law. But I think, without wishing to, as I said, avoid answering the Lordship's question, that brings me to the point at which it makes more sense for me to hand over to Mr. Sozier to deal both with the matter of construction of the contract as a matter of Mauritian law and to answer your Lordship's question further in relation to the scope of the appeal. May I simply mention, however, on the question of law and fact as a basis of appeal, that the first time that this issue, that the appeal was limited to one of law, was raised was in the respondent's case for the purposes of this hearing. It is not an issue that has been raised before the Supreme Court of Mauritius.
Well, if our jurisdiction extends only to questions of law, it doesn't matter whether the point was taken or not.
Right.
I mean, we can't sub silentio acquire a jurisdiction which we haven't got.
Good prejudice point, though.
It's a good prejudice point, exactly. It wasn't taken,
Well, we all
and
know-
wasn't taken
Well,
on
the
the basis
prejudice
of
has now
objection.
been achieved, so perhaps we can get on with the issue.
But I mean, it'd be interesting, was this issue, it wasn't discussed at all?
No, not at all.
Did the Supreme Court deal with factual issues?
Yes.
It dealt with everything,
Yes.
didn't
B-
it?
Before the Supreme Court, as your Lordship might have seen, there were 65 grounds of appeal which covered all aspects of the award, and all of those matters were dealt with, in some instances, very, very shortly by the Supreme Court, but they certainly canvassed or covered matters of fact, and the Supreme Court reached short conclusions that the arbitrator had simply been right in fact. But Lord,
In some of those respects, the findings are concurrent, aren't they?
some of them, yes, very limited. Yes.
Wait a minute, we've only got one instance here, haven't we?
We've got two, one in relation to the mechanical and engineering works and one in relation to the financing charges.
Concurrent findings, we've got, just give me the history of the proceedings. We've got the award,
Yes, the decision,
challenge,
yes,
yes?
the judgment of the Supreme Court, which dismisses all grounds of appeal, and for the purposes of this appeal, the limited grounds
So we
that are
can't be
before
said to
you.
have concurrent findings of any courts below.
No, my lord, no. As I say, without wishing to avoid answering your lordship's questions, I think we have come to the point where it makes more sense for...
Somebody's going to educate us. Probably.
Someone's going to educate you on Mauritian law, and it's not going to be me.
No, but it may be with your expertise and background, you may also be able to help. I don't know, but somebody's going to educate us on the significance or insignificance of the form of the interim certificates, which you say is the only point which was actually
Yes.
relied on below or before the arbitrator.
Yes.
Because you mustn't assume that we're all familiar, or any of us necessarily, with interim certificates in building arbitrations, or what form they would take if this were a lump sum contract, and what form they take if it's a
Measure and value. Yes.
What
The short answer is it's not very different, because the point about interim certificates, but I will take your lordships to the relevant clauses in due course.
You're going to come back on this.
I can deal with it now, or I can come back to it, whichever you prefer. Should I deal with it now?
Well, I leave it to you.
All right, I will deal with it now so that it's, with I hope, out of the way.
Because we got 2 copies of interim certificates in the bundles, haven't we? Only?
Well, they're interim valuations. The way in which, let me just find the correct reference within the contract. Oh, no, I'm sorry. Just give me a moment. You will want to turn to page 4715.
Which bundle is that in?
So I
Volume
don't have
12.
a bundle number.
Yeah.
It's clause 30 of the JCT.
It is clause 30 of the JCT. I'm sorry, I don't...
It's volume 12.
Volume 12,
for
thank
that-
you very
for
much,
that
my lord.
reference. And
Volume 12 is one of the few ones which is useful in that it's got the contract.
Yes. The contract actually starts at page 4645, but as my lord rightly says, clause 30 is the relevant clause. And it is perhaps material to look as well, though this is addressed in the appellant's case, at slightly earlier, clause 14.2 1 and 2, which is at 4679.
Right.
So there is under the contract, and the references for all of these are given in the appellant's case, a contract sum, which, as your lordships know, in this case is a lump sum of 100 million rupees. Clause 14 on page 4679, and in particular 14.2,
Yeah.
provides that the contract sum shall not be adjusted or altered in any way whatsoever, otherwise than in accordance with the express provisions of the conditions, and subject to clause 2.2.2.2, which has been deleted, exactly, although that's not reflected at this point in the contract. So that is key to the point that I've dealt with very shortly at Lordship's suggestion as to whether or not this is a lump sum or a measure and value contract. It is clear from this, we say that the way the contract operates is you have a contract sum and you adjust it upwards or downwards in accordance with the terms of the contract. Those terms include provisions, for example, for the instruction of variations, for the valuation of loss and expense, for the deduction of liquidated damages, and matters that are, to people like me, everyday meat and drink in construction contracts. When one turns to paragraph 30, certificates and payment, which is page 4715, you have, as I put it a moment ago, the mechanism for the making of the payments. So the clause does not affect what is to be paid under the contract, but how it is to be paid and when it is to be paid. And the clause anticipates, I put it that way because, as your lordships appreciate, this isn't what happened, that the architect shall from time to time issue interim certificates stating the amount due. And then at the end of the day, there is, so to speak, a final accounting, and there may be, but frequently is not, a final certificate that sets out the final sum. If you turn on to clause 30.2.1, that tells you what shall be included in an interim certificate, subject, as you see, to a retention, so a proportion, a percentage of money's held back until usually defects have been put right and so on.
Sorry, where are you now?
I'm sorry, I'm on clause 30.2.1, page 4718. This, as I say, is the clause that tells you what is in an interim certificate.
Basically, it seems to be a valuation of the work
Properly
done.
executed, exactly.
It's not looking at the lump sum and taking a percentage of it. It's actually valuing the work done, is it? Or how?
Well, my lord, it's a good question, but the point is, in a sense, exactly that. There are a number of ways, and the contract doesn't prescribe, that the architect, assisted by the quantity surveyor, may value the work done. It may be, in certain circumstances, that it's possible to say 5% of it has been done, there's this amount in the contract for it, therefore on the interim certificate you get 5%. If you can't do that, a very common practice is at the interim stage to measure the volume of work done and apply a rate to it, which may be a contract rate or may be a reasonable rate, in order to get a valuation of the work that has been done and properly executed. How does that relate to
this lump sum?
Well, the point is that it doesn't.
Does it have any contractual effect?
No, it doesn't.
Not at all? It doesn't tell you what you've got to pay on an interim basis.
Precisely.
You can say, I'm not paying anything on an interim basis, can you?
Well, you can, subject to the housing grants construction, in this country, subject to...
You have this complicated business where it's...
Yes, exactly.
Arrangements and so on.
In this country, you have rather complex arrangements.
There's no obligation to pay anything until the lump sum is due. Is that right?
No, my lord, it's not. There's an obligation to pay the interim certificates, to issue them on a
That's
regular
That's clause
basis.
30.1.
Yeah.
Clause 30.1
Exactly,
requires
yes.
the interim
So-
process to be carried out.
Yes.
You may be able to challenge the interim certificates, but subject to that, you have to pay them.
Yes, yes,
The-
exactly.
The truth is, the rate is, I mean, have we any idea, we'll come to the interim certificates, as to what rate you would charge work at? Because looking at the bill of quantities in this case, it doesn't give a rate at all. So,
No.
I mean, presumably, one of the problems with this contract is that the architect would either have to try and extrapolate the rate from the
Well,
lump sum in the bill of quantities, or alternatively, he would just take what he thought was an appropriate rate, and you say at the end of the day it would all come out in the wash because everyone would then look at the contract
Exactly.
in terms of
Yes.
variations.
My client's position, as your lordships will appreciate, your lordship's question makes clear, is that there was no bill of quantities incorporated into this contract.
Well, you've lost that on the facts, haven't you? It's been held. I thought that the document at page 534 was the bill of quantities.
There is a document. There is
Contract refers to the game.
Yes, but the contract refers to a bill of quantities that has been signed by both parties, and the document relied on was never signed by my clients. But it's only featured in the argument. There is a suggestion in CC's case that we have now conceded that there was a bill of quantities. We haven't done so, but I've advanced the argument in the appellant's case on the basis that whether or not there was a bill of quantities wasn't material.
You have to
Well,
accept
my lord,
that.
very well. It's not key. My whole point is it's not determinative of the nature of the contract. So if one assumes that there is a bill of quantities, which is used for valuing variations, it is a document to which the
But it's for valuing valuations of what?
variations, my lord,
Variations of what?
to the work.
Variations to the work.
To the work. So the
Not
contract.
to the lump sum.
Yes and no. The contract provides for the instruction of variations to the work. So, for example, the addition of another wall or another piece of wooden panelling or something of that nature, or indeed the omission of a wall or some wood panelling. If that happens under the contract provides that change, if I can use that word rather than the word variation, to the works is valued in accordance with the bill of quantities, and that's what the bill of
So then
quantities
is the
is
lump
used for.
sum altered up or
Up
down?
or down, yes. And that's provided for in the contract. Again, I can take you to them, but all the references...
Clause 13.4.
It is, yes.
You take the lump sum, but you
You take it up or down.
take it up or down according to variations, but you can't alter the basis.
No, and that's the point about clause 14.2, which in effect says you can only alter the lump sum up or down in accordance with the terms of the contract. Not you can dispense with the terms of the contract and simply start measuring the work from scratch, from the bottom up, so to speak. And that's the difference. And so to go back to the interim certificates, the point of the interim certificates is, I don't mean to sound a bit disrespectful in making a submission that is utterly trite law, but if a lump sum contract is an entire contract, in principle nothing would be payable until all the work was completed. The construction industry couldn't work like that, and the standard form contracts do not work like that, and in this country legislation requires them not to work like that. So the standard form contract provides for the issuing of interim certificates, usually on a monthly basis, which are to be paid by the employer to the contractor in accordance with the certificate, but it is, of course, as my Lord Lord Clerk suggested, open to the employer to dispute the amount that should be paid on the interim certificate, and to...
You've got to dispute that in arrears, hasn't he?
Yes, he does. He does. But at the end of the day, the interim certificates may be adjusted. The whole point of them is that they are interim. So they may be adjusted. So if it becomes apparent on interim certificate number 5 that something has been overvalued in interim certificate number 3, an adjustment may be made in interim certificate number 5. They aren't written in stone throughout the contract. And when one comes to the end of the contract and has to ascertain what the contract sum, capital C, capital S, now payable is, you do that in accordance with 14.2 by making the adjustments that you are permitted to make in accordance with the terms of the contract, and only in accordance with those terms. What happened, as your lordships know, in this instance, was that although an architect was appointed under the contract, Mr. Collijan, he did not exercise the functions of the architect.
And he was appointed by whom?
The employer. He's always appointed by the employer.
You should have been.
He's appointed by the employer, but named in the contract as the architect. And in this instance, he did not exercise those functions. There was a gentleman, Mr. Bartier, who acted perhaps most accurately as architect with a small a rather than a capital A. He issued, for example, without any demur from CCE, the certificate of practical completion, certifying that the works were complete, but he did not issue interim certificates for payment under clause 30.1. The parties proceeded on the basis that Mr. Jadoo of AJP and Partners, who is named in the contract as the quantity surveyor, capital Q, capital S, another defined term, was valuing the work and issuing interim valuations, and it was those valuations that were paid, very much in the manner of interim certificates, but not strictly in accordance with the terms of the contract. And
did that amount to a variation of the contract?
Only to the extent that payments were being made on a valuation issued by the...
Well, the answer is yes.
Yes, I suppose it did, yes. But it did not, and this is what is crucial, it did not amount to a variation, as I said in answer to the previous question. It had the effect of changing the contract in respect of the mechanism for payment, but not in respect of the method of valuation or the sum ultimately payable under the contract.
Is there a provision for interim valuations as such, or is it simply an adaptation of clause 30?
It's clause 30, yes. There are in relation to certain things like variations, provision for the quantity surveyor to value, and at the end of the contract...
But in your case, is in effect, you have to read section clause 30 as though it referred to his valuations rather than to an architect's certificate.
Yes. In effect, that is what the parties did. Yeah. But there's nothing in that, and this is my position, there's nothing in that could conceivably lead to the conclusion that the parties had agreed to change the basis of valuation of the contract sum payable on the final account. It may be, and indeed appears to be the case, that some of those interim valuations were achieved by measuring work and applying rates to it. But that is, as I said before, one of the ways in which one might make an interim valuation. It can either be a percentage of the work properly executed, or there is a rate, a reasonable rate, or one that's agreed applied to the work that's been measured as a way of getting an interim certificate. But the issue here isn't about interim certificates or valuations. It is about the ultimate contract sum, capital C, capital S, payable under the contract.
Which is the provision which deals with the final?
It's further on in clause 30. It's... hang on. Oh, that's retention. If you go to 30.6.1 on page 4722, this is where it starts. It's fairly long and complicated, but in summary, it provides the contractor, this is 30.6.1.1, not later than 6 months after practical completion, provides to the architect or the quantity surveyor the documents that they need for the purposes of adjustment of the contract sum. And then the architect or the quantity surveyor, if so instructed, prepares a statement of all the adjustments to be made. And if your Lordships look at 30.6.1.2.2, and I can only apologise on behalf of the Joint Contracts Tribunal for the numbering, the quantity surveyor prepares a statement of all adjustments to be made to the contract sum as referred to in 30.6.2, other than...
What are you reading now?
I'm in 30.6.1.2.
Oh, yes, I'm with you.
Point 2.
Yeah, I'm with you.
You see why I apologise for the numbering, but so what happens under this clause is, following practical completion, that is completion of everything other than making good of defects and minor works, there is a submission by the contractor of, I'm going to use the expression final account. It's not a contractual expression, but it's the easiest way to describe it, of the documents needed for the final account, and then a preparation of the final account by the architect or the quantity surveyor, which involves the quantity surveyor preparing a statement of all the adjustments to be made, and the adjustments which are then set out in 30.6.2, you can see just by glancing at it, are deductions of certain amounts from the contract sum and additions of certain amounts to the contract sum, the key words being in 30.6.2, the contract sum shall be adjusted as follows.
As a matter of interest at some point, can you tell me why the contractor's statement or Mr. Jadu's statement, final statement, didn't meet that criterion or adopt that approach? I know that in the arbitration it appears to be a fundamental issue,
It's because...
When you look at the form of his statement,
Yes.
which is, I think, in bundle 3, page 1361, it appears on the face of it to do what you say should be done.
No, it doesn't. I'm sorry, Lord.
Well, I'm sure I'm wrong, but
It doesn't, and it doesn't for this reason, and it is slightly difficult to follow without further information.
Sorry, could you give me that again? Bundle
3, page 1361.
The bill of quantities to which your Lordship referred a moment ago,
Yes.
Contains certain figures for elements of the work. Those figures are identical to the figures that appear under Mr. Jadu's omit section.
Okay, that's helpful. That answers one question I had, yes.
So what he does is he takes out the whole of the value of that bill of quantities, which actually only comes to 88 million rupees, not 100 million rupees, as can be seen on the face of the document. And then what he does under the heading add is he puts back in the work actually done.
And what's he omitting it from?
Oh, well, that's a very good
Well,
question.
he's omitting it from the contract sum.
He's omitting it for the 100 million rupees, even though it doesn't amount to 100
Yes, but
million
what was
rupees.
in the contract sum to begin with?
The whole of the works as described.
Every bit of work.
Yes. That being the nature of the lump
How do you
sum
know
contract.
what the work is?
Because it's what is described in accordance with the contract in the contract itself, the specification, the bills of quantities, the contractor's proposals, and so forth and so on. There is a definition of the works at the beginning of the contract, which is set out. I think the easiest thing is to see where it's set out in the appellant's case, where it's drawn together. So it's in the appellant's case, it's paragraph 28. Page 10 of the, it starts on page 10 of the document. Article 1 of the contract, 6115 is the bundle reference. And the way the contract works is to define the works with a capital W as the work shown upon, described by, or referred to in the contract documents. The contract documents are then defined as the contract drawings, the bills, the employer's requirements, the contractor's proposals, which is what you have where the contractor is designing part of the works, the analysis, articles of agreement, conditions, and so on. And then the contract drawings are further identified in a further recital. So there's an element, if I can put it this way, within the standard form of knitting documents together to find a definition of the works.
So could you, by looking at these documents, one referred to on page 11,
Yes.
would you find somewhere in those a figure for, say, basement?
If you looked at the document that has been identified, which, as I said, my client's dispute was part of the contract, but except for the moment I'm, so to speak, stuck with, as the bill of quantities, yes, you would find a figure for the basement because that's the figure that Mr. Jadoo has omitted. But you can see at a glance...
But he's added some in too.
Yes. So what he's done, in effect, because he's taken out... He's got 88 million rupees worth of work in that bill of quantities. He's taken that out, so he's left 12 million in for some reason. And then what he does is he adds back in what work was actually carried out, he says, on a measure and value basis. So he then measures what was done. He may be right or he may be wrong, but the principle of what he's done is to then measure the work that was done and apply to it the rates from that bill of quantities, schedule of rates, whatever one wishes to call it. And the effect of doing that is to measure the work and value it from the bottom up, because you've taken everything else out, rather than adjust the 100 million rupees.
So where it says omits, that is simply to remove everything.
To remove everything, yes.
Under basement.
Yes, apart from,
So
and to remove everything under the...
Start with naught.
Well, in fact,
And
for
then
some...
then you, for some reason, put in
Yes.
15.3 million.
Yes,
I'm a bit puzzled, because if I think you said a moment ago that he takes the bill of quantity rates. Is that right?
as we understand it, yes.
Well, if he does that, what's your complaint? He's done the contract work. He's valued it at the contract rates.
Well, that's...
So, and it turns out actually less than the bill of quantities figure.
That's the point. In principle, the answer to that question is because what he's doing is measuring and valuing. In practice, the issue arises because my client's case was in the arbitration that he had failed to omit everything that he ought to have omitted because they had not carried it out when it formed part of the works as defined that fell within the lump sum. Now, I can't...
But on that basis, it seems to boil down to a difference of fact rather than a difference of approach, because he is, he's accepting that his clients, that the contractors haven't done the whole of the bill of quantity works, because that follows from the fact that he's taken the bill of quantities rates and applied it to what he's measured as works and come to a lesser sum. So what's your complaint?
That he hasn't, what he's done is simply remove, because the figure in the omits column is the total in the bill of quantities.
Yeah,
so he's simply taken out all the work and started again.
Yes, but what's wrong with that? I mean, if he were doing it on a variation basis, he should have started with the original bill bill of quantities figure, and then he said, looking at the quantities in the bill of quantities, they haven't actually done the whole of that, or had to do the whole of that. They haven't used up the provisional sums. What they've actually done is 90% or whatever of the bill of quantities, and therefore they get the bill of quantity rates 90%.
Yeah.
And why is that inconsistent with what he's done? He's, in some items, he's come to the conclusion they've done a bit more work, and some items he's come to the conclusion they've done much less. I mean, take the finish.
But Lord, the
they've
question...
done much less. So take sanitary installations, take provisional sums. Those are all credits, and that's why the ultimate total is only 70 million.
But Lord, the answer to the question, I think, comes out of the question. You can see from the way which Lordship has asked the question, that what he's doing on that basis is he's starting from zero, yes, and just measuring what has been done applying these rates. My client's position is because you start with the lump sum, this is all irrelevant. These rates are all irrelevant and these quantities are all irrelevant. They're simply there for the purposes of valuing variations. So on the lump sum basis,
what?
To the works.
Yes, but if he took, I mean, I don't know whether you're right or wrong, but I think you're saying that in ads, he has actually taken the bill of quantity rates. He somehow extrapolated them from the bills of quantity.
But he hasn't taken out enough in the first place because he hasn't omitted from the 100 million all the work that was not carried out.
Well, that's a factual issue. That's not a question of principle or law.
Well, my Lord, I entirely agree with that. But
your case is essentially, let us look at the, he should have looked at the bill of quantities. He should have started with 88 million. Right? He should have started with the contract figure, but actually if he'd started with the contract figure and then decided that they did 50% of the work, you'd get down to 50 million. Hasn't he done roughly that approach in relation to, by starting with the actually bill of quantities figure, which is in a sense in your favour to start with?
well, my Lord, it may illustrate the point. If it just gives me a moment, if I can show you MSC's case in the arbitration, which I would do if I could find the right file. In the I'm sorry, slightly dangerous. In the arbitration, if I'm sorry, I don't know which volume this is, but if one looks, for example, at 2564,
I think it's the same volume. Well, we will. That's 2564. It's volume 6.
Grateful, thank you. This is. You will have seen the references to the report that was prepared by a quantity surveyor, for MSC in the course of the arbitration, a Mr. Bowler. And this is, simply to illustrate the point, a summary of the final account as prepared by Mr. Bowler.
Yes.
And it's not, for the purposes of this appeal, it's not primarily my case to argue that he's right or he's wrong. But you will see, for example, that he has identified under the heading of variations, further variations including additions and omissions. So he has the contract sum, this is the right-hand column, and he's then dealt with omissions and additions. And you can see two significant sets of omissions valued by him at 19 million and 16 million rupees, about halfway down, which are, he says, not identified by Mr. Jadoo.
Yeah, but basically that's a complaint that Mr. Jadoo has included in the ads items which the contractors didn't actually do.
Or he hasn't taken out of the omits items that the contractors didn't actually do.
Yes, I see.
And the difficulty with this arbitration, the fundamental difficulty with it, in my submission, was that because the arbitrator concluded that the contract was or had become a measure and value contract, he never examined the detail of, if I can put it rather broadly, the adds and omits, because he simply accepted that Mr. Jadou's valuation was right because it measured all of the work that had actually been done and applied a rate to it, and that came up with the figure. So he never...
Is that a complaint about the approach to valuation? It's really a complaint that if you're measuring and valuing something with a view to charging someone, you shouldn't measure and value things which they haven't done.
Well, yes, in one sense, but you have to start with the proposition. You have to start with assessing what is within the lump sum, what are the works within the lump sum in the first place. Now, there may have been, indeed there were, substantial arguments between the parties as to what was included in the lump sum in the first place, which rather reflects the question I was asked about what are the works and what is a variation to the works. But Mr. Jadou's valuation and indeed the arbitrator's assessment never dealt with those issues.
Is the 100 million sum broken down? So did the parties agree how the 100 million was made up? No. They didn't. It was just a ballpark figure. Yes.
It was a lump sum of 100 million.
Yeah. What
are you saying will happen? Has to all go back again and start again?
Well, my lord, yes. We have based a ground of appeal on the report of Mr. Bowler on the basis that it was the only evidence before the arbitrator that approached the matter in the right way.
He was rejected.
I appreciate it may be going too far to ask your lordships to accept that report wholesale, and it leaves the only alternative as being to go back and start again. But if
the
that is
alternative is to say, well, the arbitrator may have made a series of errors. They're all errors of fact, and there's nothing we can do about it. And this is just one of the snags about arbitrating.
Yes, my lord, I understand why your lordship says that, but if the arbitrator has dealt with the facts on a fundamentally misconceived basis as to the nature of the contract and the application of the terms of the contract, then that, in my submission, is a matter of law, and it undermines the decisions that he has then reached on fact in a way which is either purely a matter of law or a matter of law in the sense that the decision is so perverse that it can't stand because it's just on the wrong basis.
Well, can I clarify two things, or can I seek clarification of two things? Were there the equivalent of architect's variations made during the course of the contract? Did Mr. Jadou issue?
No.
There weren't?
No.
But works were varied from...
Yes.
Yes. So how, in your mechanism, do you operate that?
Well, a variation to the works. The architect has what is in effect a delegated power under the contract to change the works. The parties, it's always open to parties to agree, if you like, ex-contractually, that they will that they will change the scope of the works. Yes. If it's commonplace, I'm sorry if I'm veering into giving evidence, but it's commonplace for a contractor to carry out works that he says are varied works. He hasn't got an instruction to vary the works, and he goes back in the course of the dispute either on an interim certificate or a final account and says, well, I ought to have had an instruction to vary the works.
And you say you looked at the bill of quantity rates to do that?
You do specifically in relation to variations.
Yes.
Or it is one way in which you can do it. There are different ways of valuing variations. If the work is, and this is provided for in the contract, if the work is the same as or similar to work for which there is already a rate in the bill of quantities and carried out in similar conditions, you use the rate. If the work is different from and or the conditions are not similar to, then you use a reasonable rate. I'm summarising, but that is in effect the provisions of clause 13 in rather more detail.
Yes. But did the arbitrator have before him the extent of the variations and the way they were properly valued?
He had extensive documentation from both parties as to their respective contentions in that respect. But Mr. Sothey is probably better placed to answer this question than I am, since he was there. The parties agreed that the arbitrator would have put before him written witness statements which would be sworn, although it appears that many of them were not, and the parties would be free to make comments on the respective statements, but without them being cross-examined. The end result was that very few witnesses were actually cross-examined. The principal one was Mr. Jing, and his evidence was of limited relevance to the issue of variations. That was agreed. Yes, my lord, it was. It was agreed as the procedure.
Can I just go back to 2564? At the top of the page, we start with the contract sum.
Oh, yes, I'm sorry.
And then we get some sort of explanation as to how you get down to
Yes.
somewhere near the bill of quantities figure, though it's not precisely the same. I don't understand what the item is there, really. What is contractor's design for?
The contractor's design portion is, this was a form of contract. It's sometimes more loosely called with contractor's design, known to most of us as a design and build contract.
So this is a provisional item. Is it for, or is it a?
This was one. This was again one of the issues in the arbitration. There was, the contractor was obliged under the contract to design some of the works. That was set out in the contract. He was also then to build or install the works that he had designed. Within the contract, there is provision for something called, within the standard form, there is provision for something called a provisional sum, which is work that may or may not be instructed by the employer. If it isn't done, you take out the provisional sum. If it is done, you take out the provisional amount and you put in the actual value. There was a dispute between the parties because the references to the nature of a provisional sum were deleted in the contract, but in the bill of quantities, which, as you know, was hotly disputed at the time, there was a list of provisional sum items, and those items included the installation, no reference to design, the installation of the works which the contractor was to design. I'm afraid that's slightly complicated, but the end result is that there was again a significant dispute in the arbitration between the parties as to what should be taken out for the work that the contractor was designing. And that features in this appeal because it's relevant to the very specific issue of the mechanical and engineering works, which forms a separate ground of appeal. But in terms of what is happening on the face of the document, it's taking out that amount, although there was a dispute between the parties as to whether that was a contractual provisional sum. I said quite some time ago that I was going to sit down and hand over to Mr. Sauzier. It may be...
Could I ask one more question before you do? And that's this. But if you accept that there were actual significant variations of the contract for which there were not architect's variations, which would have altered significantly the lump sum, and if you accept that one of the legitimate measures, if if variations had been issued, would be to look to bill of quantities rates. Then at the moment I'm struggling to see what in principle is wrong with what Mr. Jadoo has done. But I mean, you can perhaps explain that to me.
Well,
I accept there may be a dispute that he's omitted things, or has failed to omit things he should have omitted, and has added things he should not have admitted. But given that there was significant departure from the original contract, and that the parties didn't operate the contractual processes by which that should be done, namely architects' variations, what is wrong in principle with what Mr. Jadoo has done?
The only way, Lord, I think I can answer that question is to say that what's wrong in principle is that he's omitted everything that he thinks falls within the 100 million. It clearly isn't the whole of the 100 million because he's only omitted 88 million and then he's added back in. So he hasn't actually done what your lordship is referring to, which is address what works were varied, what value was in the contract for those works, and make the relevant additions and omissions, which is what the quantity surveyor appointed by MSC sought to do in the report, which I've shown you one page of, but which is extremely lengthy, and which the arbitrator dismissed. It's no exaggeration to say out of hand.
I mean, just looking at 1361, although he puts contract sum at the top,
Yes.
does it play any part in the ultimate amount due to the contractor at all?
No.
It doesn't?
No.
No, because the amount due is his valuation of what's done,
Yes.
less certain retentions and previously paid.
Yes.
So, I mean, on that basis, Mr. Jadoo has, completely ignored any sum due in respect of contractor's design, or are you saying that there was no contractor's design so that he rightly omitted that? Because I see that on page 2564, which is Mr. Bowler, he deducts the contractor's design portion as well, doesn't he?
Yes.
So
There was...
Can we forget about contractor's design? It just didn't happen. Is that the answer?
Some of it did, but a lot of it didn't.
So basically, both sides, although they put slightly different figures to it, have eliminated contractor's design.
Yes, but what was not agreed was how much was in the contract for contractor's design. And the point about the provisional sums is that my clients always disputed that, as I said, they were proper contractual provisional sums. But even if they were, they clearly only relate to installation and not to design.
Yeah, yes, I mean, something must explain. If you look at the bill of quantity figures, assuming 1361 is correct, they total up to 88 million, don't they?
Yes.
And that includes what you say is provisional sums for actual work, not for design.
Yes.
So the difference between 88 million and 100 million, which was the contract sum, must be due to something. And so is it contractor's design?
Or financing.
Or finance. I see.
Or in a sense, I hesitate to say who knows, but obviously from my client's perspective, the bill of quantities was not agreed, and its express role in the contract was only for the valuing of variations, not as a breakdown of the 100 million. And it clearly isn't a breakdown of the 100 million because it doesn't total 100 million.
So I'm sorry to take you back,
Yeah,
but are you correct to say on 1361, the 100 million paid no role? Because if you go to the bottom of the omits and the adds, the difference between the two is about 18 million. And what has happened, the 82 million and £3,259.52 is 100 million less the difference between the adds and omits.
Sorry, can we get that again?
Well, if you see the right-hand column, 100 million falls to 82 million because there's 18 million difference. Where does that 18 million difference come from? It is the excess of the omits over the adds. I think that is his methodology, is it not?
Yes, but the 100 million doesn't play any part in that excess because the omits come from it appears bill of quantities and start at 88 million, not at 100. That's a puzzle.
Well, he hasn't deducted the whole of the 100 million.
No, what he appears to do is leave in 12 million.
He's left in 12 million.
Yes.
Yes, but he hasn't charged your clients with the 12 million, because all he's charged them with is the difference between the 85 million and the 67 million.
But the 85 million, I think Lord Lodge is right, because the 85 million comes from 82 million
Yes.
plus 3 million,
Right.
and the 82 has to be the 70
Yes.
plus the 12.
Ah, I see. Yes, I'm with you. I'm with you. So he's added it back. Yes. Yeah. Well, that is helpful.
But if to that extent the 100 million plays a role, it is not the role given to it under the terms of the contract.
Well, yes, your complaint is that the omit column hasn't deducted
Enough.
everything.
Yes.
But let us say he'd done it correctly as a matter of principle. What is wrong with his approach, given that the variation mechanism of the contract was not operated?
Because I think your Lordship's question almost presupposes that the variations are the total omission of all of the works, and then the addition back of the work actually carried out. That must be the logical conclusion, and that doesn't reflect the terms of the contract. One can't simply, my submission, rip up the contract because in a particular respect the contract hasn't been operated precisely in accordance with its terms. It goes back to the point about the interim certificates. No, the architect may not have issued interim certificates, but that was part of the payment mechanism, not the valuation mechanism. And at the end of the day, when the parties came to conclude their final account, they were properly entitled to do so in accordance with the terms of the contract, which provided for a contract sum to be adjusted, not to be ignored. I mean, the effect of omitting the whole 100 million is to ignore the contract sum and treat this as if it's a measure and value.
But was there evidence before the arbitrator in a witness statement from Mr. Jadoo explaining what he'd done?
Yes, there was, and I believe that was that he had sought simply to measure the work that had been carried out and apply value to it.
Thank you.
So you say at the bill of quantity rates? Or
yes, yes. I can give, I'm sure it's give me one moment, I can give you the reference to his statement, which I think he did verify. His statement is at 685.
Which bundle's that? Two.
Two.
Yes, number 2.
Yes, where he explains part of the 12 million difference on page 690, where he says the 11.789 million rupees for preliminaries is neither omitted nor added.
Yeah.
This was a lump sum which wasn't adjusted. It's therefore not shown in the final account statement at all.
Sorry, where is that? That's
Page 690.
Yes, I'm just trying to find it on the page. Whereabouts?
Third of the way down, the contract sum of 100 million rupees was adjusted
yes.
as follows.
And what he says is in relation, for example, to basement concrete and block work, and he repeats this in relation to most other matters.
Yes, but just...
I'm sorry.
But I think this is quite important we understand what's been done. The 88 million, which you say is an inadequate omission, is 88 million, but not including the preliminaries. If you add 11.789 million to the 88 million, you get...
Then he has omitted the whole.
So he has explained why he has worked from the 100 million. He may be wrong what he's done, but he's explained what he's done.
And he seems to be treating this as a lump sum contract, which you need to, in respect to which you need to cater for some pretty major changes. Look at the paragraph about just under halfway down. In order to work out the true effect on the contract sum caused by those major changes, and due to that the whole scope of the works were changed, the only fair and reasonable method was to measure all the items of work that had been done by the contractor in basement, concrete and blockwork sections of the B&Q. I therefore omitted all sums for them and added actual amounts measured and certified.
But
so I agree, but he is working from the basis that of the original contract sum. And if you're right in saying he took the bill of quantities rates, so then he was still also being true to something which related to the original contract.
But what he's, I'm simply repeating myself by
okay.
saying that the effect of what he's done, and he says so in his statement, it is to effectively put a line through the contract sum, and instead of adjusting the contract sum to take account of, for example, variations, he has concluded that he can ignore it and simply start measuring from the bottom up, and that is the fundamental difference.
Yes, well, going back to Mr. Bowler, the page you helpfully showed us to it,
yes,
564 in bundle 6. Does it come back to the point in the middle of the page that the explanation for the differences between the two sides' figures is basically two items on this page, which total about 35 million, right?
It's a simplification, but yes.
and they, basically what Mr. Bowler is saying is that Mr. Jadoo hasn't realised the true effect of certain additions and omissions, and he has failed to take account, and this would be a pretty major failure if it took place, works carried out direct by the building owners.
Yes.
Well, those are, if those are correct criticisms, they are criticisms of factual blunders by Mr. Jadoo, but why are they questions of law?
Well, because they are patently, as your Lordship says, they are factual blunders.
I can't decide whether they're factual blunders, actual blunders, or not. But I mean, if they were blunders, they would be blunders of fact.
Well, my Lord, I go back to the point I'm afraid I've already made, which is because the arbitrator concludes that this is a measure and value contract, he never considers whether they are factual blunders.
Why not? Because if it's a measure, and the whole point of the arbitration was that it was open to you to argue that the measurement was wrong. You say you could go to, well, I mean, it certainly was open to you to argue before the arbitrator. This is a measurement which measures work which was never done by the contractor. It was actually done by the building owner.
Well, it may measure work. It goes back to the omission point. It hasn't taken out enough of the work that was not done.
Yes, but
for example, in that instance.
Factual point you could argue in front of the arbitrator. Did you argue that?
Oh, yes. I believe so.
Yes, we did.
Yes, yes.
Well, then you just failed to, the arbitrator erred on the facts, but this doesn't seem to be a point which you've really highlighted in your case.
Well, my Lord, I'm hesitating only because, as I said, I'm simply going to be repeating myself. The arbitrator doesn't deal with these issues. He doesn't deal with them precisely because he concludes that all Mr. Jadoo had to do, or the right way to value the work done, was to measure the work and apply the rates from the alleged bill of quantities to it. Now, that only, if you do that, you're giving no weight or value to the lump sum, because the lump sum includes the whole of the works. So you're ignoring that and ignoring what work ought to have been done within that figure. So, for example...
No, you're not. What you say is being ignored is the fact that although the work ought to have been done within the original figure, in fact, it was taken out and done, for example, by a subcontractor of the building owner, rather than by...
But if that... I'm sorry, my lord.
Yes.
If the end result of that, let us say that it costs the building owner more to do that work, then the end result is the building owner has paid more for the work than he would have done under the lump sum. So if there is, let us say that within the lump sum, ignore for the moment the bill of quantities, because you do under a lump sum contract, there is £1 million worth of work, rupees worth of work. The contractor only does half of that work, but when you measure it and apply the rates to it, you get to 750,000 rupees.
When you say when you measure what? You say it. Do you mean the whole or the half?
You measure what he is actually done. Well, no, you're not. You're measuring sorry, forgive me. The difference is if you have a lump sum, you have build this building for 100 million rupees. If you break it down, there may be X number of bricks or blocks in the building. Under the lump sum contract, it doesn't in principle matter whether you end up putting in more bricks or fewer bricks, because the lump sum is what you get paid. But under the measure and value contract, it does matter, because you count the number of bricks. It's probably an oversimplistic example, but it illustrates why you may then end up in a position where the contractor has got paid, let us say 3/4 of the lump sum, but has only done half of the work. And that's where the difference becomes important, and that's why the arbitrator, had he rightly concluded that this was a lump sum contract, would have had to address properly what work was within the lump sum and what other payments were within the lump sum, or services were within the lump sum, what had not been done, and what had been done. And he did none of that because he went off on the wrong tack, that it was a measure and value contract.
So on your
I just don't. Sorry.
No, Gary.
I just don't understand how you can say that, because what he says he did was he started with the 100, he ignores the preliminaries, he takes out what he thinks was the rest of the 100, and then because he says for example, basement concrete and block work was so different from what was done, and so he as you say, he sees what's within the lump sum. He finds out. He errs, you say, in not taking out enough of what hadn't been done, and he makes an assessment of what was done. I mean, that on the face of 1361 is what he was purporting to do.
So long as that would add up to 100 million. And you simply don't have that information and that knowledge on the basis of doing it as measure and value instead of add and omit.
Except there's also you have to add on to that, onto the 100 million, variations, because he said he's got 8.4 million in the add-on column for variations,
yes,
which he explains that in page 691 that Mr. Ujuda gave instructions for variations, and he's measured and valued those.
Yeah.
So, I mean, he'd have 108 to play with, as it were.
Well, they are variations to be valued in, I hate to say the normal way, but I would say the normal way.
Yeah.
Well, I'm afraid that I'm conscious of the time.
Yes,
and
we've got some points. We must end this.
I did say I would let Mr. Sauzier tell you about education on Mauritian law quite some time ago. So
Sorry.
I don't wish to avoid any questions that your Lordship has, but I think I ought to.
You've got some other points in the case to
Yes.
deal with as well. Mr. Sauzier.
Yes, my lords. I think that the question which I must address is whether, I won't go into the distinctions of lump sum contracts and measure and value, in view of the issues before the arbitrator. That is, I think the main issue for him was whether it was a lump sum or a measure and value. As my learned friend has rightly pointed out, the respondent's stand throughout, from the very outset, was that it was a measure and value. Until I read the statement of case, that is at page 6147, where the respondent says it was the common intention of the parties having signed a lump sum contract to depart. I think that they are wrong on that basis. And for me, my lords, the only issue that the arbitrator had to address is if it was a lump sum contract, as we believe it is, and which has been accepted by the respondents now, the next question is, was the contract clear and unambiguous? That is, are we bound by Article 1134 of the Code Civil? And your lordships will see that this article is reproduced in tab 31. It is at page 6369.
It's quoted in your case.
It is indeed, my lord. It is indeed, my lord. And of course, I will refer to the case, to the statement of case of MSC of the appellant. It is at page 6112, where there is a translation, a proper translation of article.
Which paragraph is it?
It is at paragraph 20, my lord. So paragraph 20, you've got article 1134 and the translation middle of the page.
Sorry, article which?
Sorry?
Which article did you refer to just now?
1134.
24.
34. It's quoted at paragraph 20 of your case.
20 of MSC's case at page 6112.
I'm following this in the actual civil code and tag 31.
I see.
I should be looking at 1134, should I?
1134, my lord, yes. So it reads, the translation at page 20, legally concluded agreements have the effect of law for those who made them. They can be revoked only by the mutual consent or for causes authorized by law. They must be performed in good faith. Now, my submission to your lordships is that if your lordships are satisfied that the terms of the contract are clear and unambiguous, the arbitrator and the learned judges of the Court of Appeal were wrong to have departed from the principle and applied Article 1156. Of course, there is no need for me to go through all the authorities which have been referred to by the appellants. Suffice it to say, my lords, that there are two authorities of the Court of Cassation which are in tab 13 and 15 of the bundle of authorities. And I won't read through them, it just confirms my stand. Tab 15 first is to be found at page 6248. And 13 repeats this, it's the same principle. Bundle of authorities, my lord. Same thing.
Yes. But I think this is dealing with the question of construction
Indeed.
of the contract.
Indeed.
And I think the respondent's case now makes clear that as a matter of construction of the original contract, they agree that it's a lump sum contract.
Yes.
So we don't need to, they're not trying to denature it anymore. They say there's a variation there.
So, my lord, so if we accept, my lord, that the terms are clear and unambiguous, if we accept that it is a lump sum contract, how did the arbitrator travel outside the ambit of Article 1134?
Are you submitting that 1134 prevents a contract from being varied if its terms were originally clear?
If there, yes.
That's your submission?
I would say that if the terms are clear,
Yes.
that the authorities support that view, that the terms are clear, they can only be revoked by the express consent of the parties. This is the submission.
But I mean, the suggestion is that the parties have expressly consented to an alteration of the contract. That's not, as I read it, precluded by Article 1134.
It is, if it is expressly there. No, it is not, it cannot be taken against the parties, no.
So you accept that it's possible for the parties to vary the contract?
Indeed.
Even if it's clear, but are you submitting they can't do it by conduct?
I would think that if the terms are clear, they cannot do it by conduct.
I see, but that doesn't seem to emerge from Article 1134.
It emerges from Article 1156. This is where the learned arbitrator and the learned judges said, we are going to interpret 1156, and I'm coming to that, if your lordship. So
that's in your paragraph 21. So in your case, paragraph 21,
indeed,
we have 1156, which says,
indeed, my lord,
talks about the common intention of the parties, but that's
indeed
not about variation.
But then, my lord, when we look at, if we go through, paragraph 21, indeed. But then, when we read Article 1156, the translation bottom of the page 6112, in an agreement, one should seek the common intention of the contracting parties instead of limiting ourselves. This is correct. But if we look at the notes which follow, notes 1 and 2, I think
this is in Dalloz, is it?
It is in Dalloz, but my lord, if we go in the statement of case of the appellants, there is the translation, the English translation, so it's easier to follow. 6112. So the note would be top of page 6113. There is no need for any interpretation unless the wordings of the contract are obscure or ambiguous. If they are clear, the judge should not, under the pretext of interpretation, modify, distort them by trying to appreciate the intention of the parties.
Yes, but that's all about interpretation. If we move on from interpretation, if we accept for the time being that you're right, that it was a lump sum contract.
Indeed.
We go back into 1134, and it says that the conventions cannot be, that the terms cannot be revoked except by mutual consent or for causes authorized by law. You have added further qualification to that of express mutual consent rather than implied mutual consent. Do you have authority to support the requirement of express consent?
Yes, my lord, the two authorities which I have referred to, that is in tab 13 and 15.
Yes.
13 and 15.
13 and 15.
That's interpretation again.
Indeed, indeed.
No, I mean, I think we've really got to the point where we are dealing with variation, and that's covered in a later
Yes, indeed, my
part of
lord.
your written case, paragraphs
Yes.
57 to 59.
Yes, 57.
Which we've already had.
Yes, indeed. This has been, my learned friend would say that the acts of the parties could not in any way be interpreted as being. This is what she's going to say. There was nothing. If I may say, my lords, there are two articles, 1134 and 1156. These are the two articles. When we look, I went through the authorities submitted by my learned friends, and even if we look at one, I'll take one because time is of the essence. If we take, for example, the tab 3, which is in fact an article with respect to Article 1156. It is in French, but obviously I've done a part of it.
It's fairly obvious what it says, and it has its homologue in common law as well.
Which bit are you reading?
My lord, it is at page, I don't know whether your copy is readable. If we look at
Which paragraph?
paragraph, it's paragraph 1 of page 106, when we look at page 106.
106.
106.
106.
It's in, I'm sorry, my lord, it's 6200. I'm sorry, 6200.
Yeah.
106 of the article.
Right.
Well, okay.
So which part of the text are we looking at?
My lord,
C'est la loi.
third line from the top.
From the top, right at the top.
Do you wish me to read through that in French or in English? I've got the translation.
Well, shall we just identify how much you want to read?
It will start with "Il arrive trop souvent,"
Oh, yes.
up to "interpréter." That is the bottom of this paragraph. If your lordship wish me to read it in English, I'll do it for you.
Probably read it for ourselves in French.
It happens too often that by fatality of our weaknesses, the acts seem or are actually obscure, ambiguous, full of uncertainties and contradictions. It is then that we must complete the insufficiency of expression, rectify the impropriety of terms, choose the actual consent over multiple consents, limit any exaggeration from the inconsiderate use of an expression, reorder sentences, harmonize clauses in its natural and true meaning of the entire act. It is only then that there is a need to dissipate the obscurity, erase the ambiguity, fix any doubts, and clear any confusion that is, in one word, interpret. If we go throughout this article, my lords, the same line of thinking, I've got all of it translated.
It's all dealing with interpretation, which we've dealt with.
I mean, how does this help us if we've moved away from interpretation? Let us assume, subject to what the respondents say, that the board was with you on the question of interpretation. It was a lump sum contract.
Indeed.
1156 helps us not a jot in relation to variation. It's irrelevant to variation.
Yes, but then I will, my learned friend has explained that technically, the mind of the arbitrator, my question is, was he right to interpret, to come to the conclusion it was not a lump sum contract? This is the issue for him. It is the main issue. Is it a lump sum or a measure and value? He came to the conclusion
that way, but I mean, effectively, what he was saying was that the parties established for themselves in the course of their conduct after the contract was made something which was not a lump sum contract. Now, that is really incapable, this as I understand it, why the point is being conceded by your opponents, that if you've got a contract which starts as a lump sum contract but becomes something different afterwards, you can call it a matter of interpretation, but actually it's an alteration of the contract by mutual consent.
Yes. No, I would say, my lord, that what happened afterwards does not change the fact that it is a lump sum contract.
That it was originally, but you accept that in some circumstances a variation can change a contract, and here there was clearly some variation by conduct because the parties agreed to use a quantity surveyor rather than an architect.
Architect, yes.
And they agreed to dispense with architect
Yes.
certificates and have
Yes.
quantity surveyors' valuations, and so on. So certain variations by conduct are possible. The question here is really ultimately a fact.
Yes.
Is there a variation here?
Yes. Was the arbitrator right in his framing, in the frame of his mind, to come to this conclusion? This is the
The
question.
trouble is, I mean, what one can say of the arbitrator, that it's all very well to say that he said if I'm wrong, then there was a variation. If I'm wrong about construction, but the truth
Yes.
is he started from a wrong premise, and it may have influenced his general thinking. But we've got to deal with the position in principle.
Indeed, because the arbitrator himself says that it is clear that when we at page 452, it is you will see, my lords, at 452 of the bundle. It's volume 1, whole bundle.
Yeah.
452. Last paragraph, 514. He says, as far as the genesis of the project is concerned, I find that in the actual case, the wordings of the contract are clear and unambiguous. He says so. It is a situation where the terms of lump sum and turnkey contract have been used in certain correspondences, documents, which during negotiation stage, prior to signing of the contract, but not in the contract, or any subsequent...
Again, I mean, what he says is difficult to understand.
Indeed.
Because basically, he isn't there construing terms of the contract, unless he's saying that because the words lump sum don't appear in it, it's clear and unambiguous. But later on, he says there isn't a clear-cut answer at 5.17.
Yes.
But, I mean, we are prepared to proceed on the basis now, because effectively, Monsieur Ribot, as I understand, accepted it, that this was, in its genesis, when it was signed, a lump sum contract. So the question which interests us now is, was there a variation? We've heard Ms. Jefford's submissions on that and on the significance of the interim certificate or valuations. Is there anything you can add on that aspect?
No, I won't add on what Malone has said, because I don't think that these departures, if I may say so, are enough to justify that there was a major change. My thinking is, was the arbitrator and the Court of Appeal in the proper frame of mind, or did he come to the wrong conclusion? Did he come to...
Well, it matters very much for our purposes whether, if he came to, assuming he came to the wrong conclusion, he came to the wrong conclusion because he got the facts wrong, or because he applied some erroneous principle.
My lord, I'm sorry to interrupt, if he comes to the conclusion that the contract is clear and unambiguous, because in the contract of the 3rd of December, that is the major contract, there was no word lump sum, I think he's wrong, because today
But I'm
he's
interested
wrong.
in what the nature of his error was. Was it an error of law, or was it an error of fact? I mean, the reason why I ask this is that under Article 1027
Yes.
of the Code, there is a right of appeal
Yes?
unless the parties have, in the arbitration agreement, renounced that right.
Yes. So there is a right.
Now, in this contract, the parties have reserved a right of appeal on questions of law. Now, that would be a completely meaningless reservation unless the parties were actually excluding every right of appeal other than on a question of law. Now,
Right.
if that is so, then we need to decide whether the arbitrator simply decided on an insufficient factual basis that there was a variation, or whether he committed some error of law. And that seems to me at the moment to be your principal difficulty.
All right.
If, I'm speaking for myself, I very much doubt whether, if the totality of the evidence consisted of the facts set out in the award, I would have concluded that that was a variation. But he seems to have thought that as a matter of fact, there had been a variation. And that seems to me to be something that was for him and not for a court hearing an appeal on law.
I would submit, my lord, that I agree that when we look at the contract, there is this clause which says that matters of law.
Yes.
But then there is the arbitration agreement. And if we take Article 1027, my submission to you, my lords, is that the appeal need not restrict itself to questions of law. I've got authority on that subject, which is not in the bundle of authorities because it was not a ground of appeal raised proper. But
it's a very critical point.
Okay, but I'm quite prepared to address your lordships on that. It will take 10 minutes, but the only problem is that the authorities are not in the bundle. I've got copies there. They are not translated, but there are few paragraphs in a big...
How do they help in the face of the contract clause? If you look at bundle 12,
yes,
page 4746 and 4747, the contract clause has been specifically adapted to suit the Mauritian context. It has been specifically adapted to refer to the Supreme Court of Mauritius and also to the Code of Civil Procedure related to arbitration.
Yes.
It only refers to appeals on questions of law. Where is the Code of Civil Procedure on arbitration? Does that help us at all?
Yes, my lord. It is. If we look at the code, it is in tab.
It's the one we were looking at.
6192.
6192. Yes. So
Sorry, my lord?
it specifically refers to the clause which.
I'm sorry, my lord. I'm not with you because we've got the in tab 1, but it is in French. Tab 1, you've got the article 1027, and my lord, in the appellants sits 1.
Yes, we've got 1027.
Yes. So when we look at...
There is a provision which says that you can normally appeal on fact as well as law.
Article 1027, if we look at first paragraph, the translation would be 10271.
Yes.
The arbitral award is open to appeal unless the parties have expressly renounced to any appeal in the arbitration agreement.
It doesn't deal with fact.
No, it doesn't. I've got authority on that.
Let's suppose for a moment that that in principle 1027 allows an appeal on fact too.
Yes.
Clearly, it is qualified by the phrase à moins que les parties n'aient renoncé à l'appel dans la convention d'arbitrage.
Yes.
So the next question we have to decide is whether the parties have renounced the appeal, and that's why we have to.
No, they have not renounced, my lord, because
that's the question.
The question can be solved.
They haven't expressly renounced, but
yes,
it might be said, but by necessary implication, haven't they? I mean, you don't provide specifically for an appeal on a question of law if you intend to have appeals on questions of fact.
Yes, my lord. Yes, but then when we appeal before the Supreme Court, we are bound by articles of the Code de procedure civile.
Of course, but that article is qualified, and it's the qualification that we have to look at. The article is qualified by reference to what the arbitration agreement says.
Yes.
Because if you read the article as amended by the parties hereby agree and consent pursuant to the Code of Civil Procedure relating to Arbitration Act 1 of 1981 that either party may appeal on any question of law.
Yes, this is in the contract.
That's the contract.
Yes.
So
indeed.
what is being put to you, given that they are referring in effect to 10271, they are stipulating the extent to which they are allowing an appeal.
Yes, my lord, but if you fall under 1027, my submission to the court is that it is, the authorities say that you are not bound by law only, you can open the case to be revisited. This is what I say.
Well, if you've got some authority, you've got quite a lot of authority, we ought to see it subject, and this is a concern for your part, subject to the question of time. You've got some other points of appeal to deal with.
One.
Who's going to deal with them? Miss Jefford?
I've got one point, the missing minutes. I will deal with it, and then the other parts. But my lord, I can be in 5 minutes. I can deal with that point in 5 minutes because it seems bulky. But my lord, there is only one note. Okay. I didn't want to extract the whole part of it, so I'll just refer, for the sake of convenience, Juris classeur, this is,
You're going to hand something.
my lord, really it is overdoing because you've got only one page in each of the
All
panels.
right, we're used to turning pages.
I hesitate to interrupt my co-counsel, but so far as the other grounds of appeal relating to the M&D works and the financing agreement are concerned, in relation to the financing agreement, unless your lordships have any questions, I don't propose to say any more than is in the written case. And so far as the M&E works are concerned, I've covered most of the points in answering lordship's questions about provisional sums. So I rise only so that Mr. Sauzier is aware that he isn't under quite as much time pressure as might otherwise appear. I hope that's helpful.
Right, thank you, very helpful to him.
So
Yeah.
the only paragraph to read out of that, my lord, I could have taken it out, but it is paragraph 93.
93.
93. This is the only...
Well, we'll keep this for future reference.
thank you, my lord.
What page is it on?
My lord,
Page 70.
it is at page 70.
Yeah.
Now, if I may, if we start at the fourth line, CA Paris, 28th of November 2002, which holds that an appeal...
Sorry, which are you reading from? From 93?
I'm just translating for your lordship. So I start with
last two lines.
the last three lines, yes, in that, the last two lines. Which holds that an appeal, grounds of nullity, allows one to obtain annulment of the award on any ground which may be considered to be valid, including the grounds specifically listed for annulment. This is the part I wanted to refer your lordships to.
Right, so what do you say that demonstrates that bears on the question we've been discussing?
Yes, my lord. May I simply refer to the other two authorities before I answer your questions? The other two authorities, first of all, there is la Cour de Cassation. This one is shorter. It is Chambre civile 2, audience publique du 16 mai 1998, 16th of May 1988. And if I may... Ah, merde, où j'ai mis ça?
Yes. This is 16th May 1988, yes.
I've got... I don't know whether... attendu que la Cour d'appel, I don't know what page it is. All right. Where it is. The first page, down, last paragraph.
Vu les articles...
Vu les articles 1484 du nouveau Code de procédure civile. Now, I start with attendu. Given that the Court of Appeal sees with the proceedings for the annulment of the arbitral award, must decide the merits to the extent that such issues are raised before it, and in accordance with the rule of procedure applicable in litigious matters submitted to it. This is the part I wanted to refer. And lastly, my lords, there is la Cour de Cassation, l'audience of the 8th of July 1987.
Sorry.
If I may, my lord, it is second page. As always, starts with attendu que. Second paragraph, last three lines. Since none of the parties have expressed
Paragraph, last few lines, yes, yeah.
Yes. Since none of the parties have expressed a contrary will, the Court of Appeal, which has annulled the arbitral award, was also required to decide on the merits, without any textual requirement for it to render its decision on the merits by way of separate decision.
Yes, but the question here is whether the parties have expressed a contrary intention.
Yes, I can follow your lordship. In the contract, it is admitted that there was this issue of law, but when the arbitration agreement was signed...
We can look at the arbitration agreement, do we?
Yes, the arbitration...
Have a look at that.
And we 509.
Page what?
509.
509.
Yes.
In which volume?
I think it's the first or second volume.
Yes, it is volume 1, my lord, at page 511.
I think it's the second volume, isn't it?
It is volume 1, my lord. I've got it bundle 1. 511.
I think.
I think it's our volume 2.
Right.
The 511.
Right.
The only reference to appeal is at paragraph 6. The decision of the arbitrator shall be binding on the parties, but shall be subject to appeal. That is all we've got.
Now, this agreement is...
This is the actual submission or terms of reference.
I mean, this is, yeah.
This is the only thing we've got. This is where I say that if there is...
It's subject to the underlying contract.
Yeah, there is nothing. My submission to your lordships is that if we bind ourselves or we agree that there should be an appeal, then we fall under Article 1027, which opens the door to the Court of Appeal. And indeed they did, because as my learned friend rightly pointed out, there were 66 grounds of appeal, plus 2 added ones. So it was never taken there that we were restricted to questions of law. And all these issues were canvassed.
This is, as I understand it, entered into pursuant to the building contract itself.
Mm-hmm. Yes, my lord.
So that the nature of the appeal referred to in paragraph 6, one might have to look at the building contract to determine it.
Does the building contract contemplate a separate submission to arbitration?
No.
Why did you have to agree this?
No, I think that's what is common. Normally, most of the arbitration proceedings in Mauritius, normally I say there is no appeal. Very often we have agreements where the decision is not subject to appeal. Yeah. So, and it goes according to Article 1027, that is, it is a right, but normally the trend is not to appeal. But sometimes, as in this case, there is the provision that there is an appeal, but there was no qualifications to it or restrictions.
I mean, as I understand it, the purpose of this document is, in fact, to define the issues. It's quite a common practice in arbitration proceedings.
Indeed.
For example, in ICC arbitrations, which are well known,
yes,
to draw up the terms of reference of the arbitrator. But that doesn't mean to say that you are displacing the arbitration agreement in the contract.
Indeed, my lord.
Or you may be supplementing it, but you are not getting rid of it. And so this doesn't abrogate the limitation on a right of appeal in clause 41 of the contract itself.
If I was to apply my mind like the arbitrator, the intention of the parties,
yes,
subsequent to that, when we went to the Court of Civil Appeal in Mauritius, the issues of facts and law were discussed. So it is clear that there was no objection taken at this time. Come on, you are limited to law. There was none of that. 68 grounds of appeal were argued before the... So it seems to me, my lord, that when we went before the Court of Civil Appeal, that both parties were geared towards an appeal on facts and law. So there was at no stage was it taken.
Right, so you say on that basis we grapple with the question whether as a matter of fact there was a variation.
Indeed.
Yes. And what material is there that you would wish us to take into account apart from what we've already looked at?
I would not add anything from what my friend has said. The only thing I would simply concentrate on both articles which I've already alluded to, that is 1134 and 1156, and reading of the authorities which have been submitted by my learned friend for the respondent. I do feel, my lord, when I read these authorities that they are in favour of the appellant, because
you do submit that, Mr. President.
I will submit that all the authorities are in favour of the appellant, because
You're not the person making the decisions.
No, because my lord, if I can, I'm limited by time, but when we look at tab 23, 17, 10, 9, 6, and 8, all these authorities are either. And even the application of Duclerc des Roches, which is in fact at tab 22, all these authorities, my lords, whenever there has been a contract between parties and it was non-ambiguous, whatever the conduct of the parties, they were bound by the writing. All these authorities, Widow Chenard, which is at tab 23, Cour de Cassation, which is tab 17 of 1971, these authorities specifically demonstrate that the true meaning of the contract of the document, that is under Article 1134, was to be followed. Even the case of Adam against Souchon, which is table 6, the same principle. My reading of this is that once the parties have expressed their minds on a contract and it is clear and unambiguous, that's the end of the road. This is my submission. So these my lord, the other issue is ground free. I'm supposed the division of labour imposes ground free on me.
Just identify what it is.
This is the
complete record point.
Oh, the record point.
The record.
Right. It's right. What do you want to say about this?
My lord, my lord, my submissions to your lordships is that the arbitrator is under an express duty to record the minutes of the arbitral proceedings by virtue of Article 1019 of it is tab 24 in the bundle of authorities. May I translate the reading of the article? Tab 24. Investigative actions and minutes of proceedings shall be drawn up by all the arbitrators if the compromis does not authorize them to commission one of them.
Now, the Court of Appeal said it didn't have, I think, or perhaps it's your opponents say this doesn't have anything to do with the present situation.
Because there are three, there is one.
Yes.
My lord, I was coming to that, but my submission is that if there is a duty imposed whenever there are three arbitrators, it is, but anyway, the court, I'll come to the decision of the Supreme Court of Mauritius, because they say that it did keep a meticulous record. So my submission to your lordships is that if there is a duty imposed on three, the same duty should be imposed on one. That is, there is a duty, and in fact, the Court of Appeal will say that it did keep a proper record. Your lordships will see at page, in the 5904, which is volume 4, judgment of the Supreme Court.
(5904), did you say?
5904, my lord, yes?
Volume 4 of the record.
Volume 4 or the bundle 4?
It can't be.
Volume 4, core bundle.
No, volume 4 is
1478 to 1828.
Something completely different.
It is of the core bundle, so c'est
So
quoi?
you say
14. 14, understand?
14.
14. Yes, I've got a summary of all the bundles. Oh, tu as 4, toi, hein, tu as core bundle. Non, parce que j'ai pas lu les 14 volumes, moi.
Which page is it?
5904.
Page again, sorry?
5904. 04.
Yes, okay.
59. So if we have a look at the last paragraph, starting the 4th line,
yes.
we do not have the slightest hesitation in view of the meticulous way in which the files of the proceedings and the documents were kept by the arbitrator and the precaution it took to make sure that the list of contents of each box appears on it, that he kept a proper record of the proceedings and sent the whole proceedings which were received as acknowledged by the registry.
Yeah. So you say that's wrong?
Of course it is wrong, yes.
No, but how can we say it's wrong? I mean,
Look-
the Supreme Court has looked at the matter and reached a clear conclusion
Yes.
On fact.
Yes.
We aren't here to decide that the Supreme Court was wrong on the factual matter, are we?
Yeah,
It says basically it all got to the court and it
Right.
something. If there's anything missing, it must have got lost during the court, and you didn't raise this point for a long time. And anyway,
Indeed.
what is its significance? Those are all
There are-
lines of reasoning.
Yes, I can understand your Lordship's point. Let us first of all agree that before the Supreme Court, it would seem, reading through the judgment, it was the main point. Out of the 25 pages of the judgment, 14 were devoted to this point, and your Lordships will see that throughout the sittings, I have been on the grill for better parts of days with both the learned judges.
But what's the underlying merit of this point? I mean, what's it got
There
to
are
do
2
with
points,
the
my Lord.
underlying-
First of all, did he keep a proper record?
Yeah, but suppose he didn't.
What's the consequence? Suppose you're right.
If I'm right,
The result, do we set aside
was
the whole award?
was he in possession of the records when he made the award? One.
Well,
Second,
let's assume that he didn't keep a proper record. What's the result? Does that mean that his award is null and void?
I would say I wouldn't say that our award is not and void. I would say that was he in possession of all the documents when he gave his award? That is the first point. Secondly, if the record was incomplete before the Supreme Court, the learned judges of the Supreme Court, they were not in presence of all the documents when they were looking at the case. Of course, I know that your Lordship might tell me that they were in possession of written notes.
Well, what I'm actually going to ask you, rather than tell you, is what is the consequence if you are right about all this? What do we do about it? According to what are you
If I'm
suggesting
right?
we should do if we conclude that you're right on this subject? What do we do with the award?
Assuming you're right on this point, but wrong on every other point. Isn't it?
My Lord, I would come to the last part of my submission, as I had prepared it, would have been when we look at the notes, that is, when the learned judges of the Supreme Court, because there are many issues which are not clear for me when I go through these minutes. I wanted to address your Lordships, but let us come to the end of my prepared submission. If your Lordships come to the conclusion, as their Lordships before the Supreme Court said, but anyway, we've got through box number 2, we've seen that there are handwritten notes of the arbitrator. First news, when we read the judgment, it was the first time that we were made aware that there were written notes. This was never, ever raised before the Supreme Court. Your Lordships will see that there have been 6 sittings over more than 2 years.
What does it go to? What issue in the case does any conceivable late revelation of notes or even missing document go to?
My Lord, important because...
Your clients were present at these hearings, were they? So they could presumably rely upon any material which they've kept a note of, which they say that the arbitrator may not have looked at. But there's no hint of a point like that. I think this is just a purely prejudice point, isn't it?
My Lord, yes. When they come to this conclusion and we say that it is novel to us, then I come to the case of Le Sage, where my friend Ribot appeared with him before your lordships, and the learned judges had been battling over years concerning this issue of a colleague of theirs, and they get this material which we never had. I never had this material in my possession. The first thing they should have done for me is to call us. It's not a question, it's not very difficult in Mauritius. And they tell us, this is what we've seen, my lords. Exactly the letter of Mr. Le Sage to the judge, where the judge should have disclosed.
Let's stick to this case. The great battles of the past.
Yes. Could I ask a couple of questions? It is recorded in the Supreme Court judgment at 5908.
5908.
Yes, in making a submission before the arbitrator, learned counsel for the appellant must have had in his possession
Indeed.
the minutes of the missing minute of the 2nd December sitting. So,
Indeed.
So you had them.
Yes.
When you addressed the arbitrator.
Indeed.
In the start of the next full paragraph, they say, we have to point out further that the transcript of the minutes of the proceedings of the 2nd December appears to have disappeared in rather dubious circumstances after the whole of the record was sent by the arbitrator for the purpose of the appeal. So how can, on those findings, how can there be any miscarriage of justice by the arbitrator?
The word which I don't like personally is after, because it is.
How can you challenge it?
My lord, I must say that if we are talking 10 years back, there is no problem about when in fact, the written submissions are there, and we can see at page 169, I think, that I make reference to the evidence of Mr. Kouchiram. There is no doubt about that. But the mere fact that when we came before the Supreme Court, we started the appeal. There were 6 sittings. Both my friend and I were before the Supreme Court. And at a certain stage, my learned friend did put in 5 missing documents because there were 7 original. 7, then 5 were supplemented by my learned friend. But the mere fact is that at the end of the day, the 2nd of December was a date which was missing. I did not have a copy, neither did my friend have a copy, because he would have produced the 6, I presume. There was no
Had it in front of the arbitrator? Well, according to this, did.
I can confirm that if I made my submission in writing and I made reference to that, certainly I must have had it. No problem about that. But then...
But where, standing that the Supreme Court, having heard this detailed argument from you, have concluded that this one document was lost after the arbitrator had sent the papers to the Supreme Court, how can that found any possible case of miscarriage of justice by the arbitrator?
My question is, how can they come to that conclusion? Because when they say he kept a proper record, he did not, because 5 of the sittings were filed in when the case was before them.
So how can you, on what basis can you challenge their conclusion?
I can't give evidence, obviously.
How can we determine that? We
My lord,
heard all the arguments that were put to the Supreme Court as to the circumstance in which this document went missing. Something has persuaded them that it probably happened by the time the court administration had the papers.
Yes, something, yes, obviously. But to say whether they were right in this interpretation, I think they were, because when we look at the documents themselves, the documents show that there was not a complete or a correct keeping of records on the part of the arbitrator.
Because 7 were missing initially, yes.
Yeah, my lord, when we look at my submission in writing before the arbitrator, when we look at my submission, your lordships will see that I make reference to certain issues concerning Mr. Kouchiram. But the gist of the case of Mr. Kouchiram is, at the end of the day, he is the only person to depone on behalf of, apart from Mr. G, Mr. Kouchiram. He said, whether there are 22 drawings or 500, it's immaterial. 22 can amount to a lump sum contract. So the learned judges don't go into that.
No, but can we just try and identify, and it bears on Lord Sumption's question, what possible prejudice have you suffered by any document not being available either originally or now?
Prejudice for me is if the arbitrator was not in possession of these documents when he made his award. If he was not,
Yeah, this is speculation. In order to set aside an award, you have to show something more than speculation. We would have to make a finding that there been injustice.
Yes, that would have been my first step, saying that was he in presence of all of this, one.
Yes.
Secondly, when the Supreme Court started the case, admittedly, 5 of the sittings were supplemented, but what puzzles me, I'm sorry to come back to that, is that when the learned judges suddenly, because I guess that they went through the file, through the brief, I guess that they must have been through the boxes, I don't know at what time, but when they finally discovered these handwritten notes, which shed light, according to them, my submission is that this information should have been imparted for us to answer, because they were mostly concerns, my lords, about this. You will see, most of the debates were concentrated on this issue, this aspect. How can you say that the documents were missing? How can you say so?
No, but I asked a different question. Why does it matter if some documents were missing? What do they go to?
No.
What difference has it made to the issues we're concerned with?
Would it not prejudice the final decision if there is an important element which is missing? Would their lordships, could they have been affected by this? I'm sorry, my lord, to come back to Le Sage. Would the same question, it is at tab 20 of the bundle of authorities. I think that the gist of Le Sage, when we look at bundle of authorities.
Powers of a court of appeal, according to Article 1027, are to annul or to vary an award.
Yes.
Are you saying that we should annul the award for this reason?
Indeed, my lord. I would suggest the same question was put to me before the Supreme Court, and I said it has to be heard anew. So, meaning you have to annul the award and start it all over again. It is unfortunate. Time has gone past. We all know that. But the mere fact is that the learned. One of the points, of course, I've taken note of your lordship's decision in the last decision of the Mauritian courts that we should not raise a new point before the board, but we should not forget that the arbitrator took more than what he was... The time.
Yes.
Because Article 1015 of the Code de Procedure gives him 6 months. Yeah. It took more than 2 years, so factus officio, technically, but we never raised it.
No, I'm a bit worried that you're taking more than the 5 minutes you said you were going to take.
No, I'll be over by 1, my lord.
I think we've probably got this point. There are other points in the case which I think...
No, they are purely to highlight the basis of my thinking, that is all. I've done, my lord. Thank you, my lord.
Thank you very much indeed, Mr. Stacey. Ms. Jafford, yes.
Sorry, Alexander. Thank you very much. That's
your blood. That's fine. Put yours there.
Thank you very much. As I said, when I was seeking not to curtail Mrs. Sauzier unreasonably, I have, looking at my notes, in fact covered most of the points that I had left to deal with. In relation, it is slightly going back to the question of variation by conduct. Obviously, I'm not dealing with the matters of law, but in terms of the conduct relied upon, there are now 4 matters identified by the respondents. The first is the absence of the architect, which I've already addressed. The second is the interim certificates or interim valuations, which I've already addressed. The third is changes to the project, which again I have already addressed. And the final one is financing. The point that CCE make is that although they have disputed the arrangements or the nature of the arrangements between the parties as to financing, they accept that there was an agreement entered into in writing in April 1994 which related to the financing of the project. My client's position having been throughout that it was a crucial matter for them that CCE would provide funding and financing for the project. That agreement, which I think is at 1443.
Which volume is that?
I'm so sorry. Oh no, I've got the wrong. Excuse me, just a moment.
I think it may be in our volume 3.
Oh no, I'm sorry. I have the wrong reference. Lordship, I'm so sorry. I'm sitting there.
It's not 1443.
The wrong reference. 1433. I'm sorry.
Yeah, it's still in the same volume.
1433.
No, that's not. Oh, yes, I'm sorry. This is right. So my page numbering seems to have gone slightly astray.
1433.
Yes, that's what I had, but it doesn't seem
There's
to
something
be.
called agreement between CCE and Mascareignes. That follows a two-page agreement.
Which relates to date of possession.
Yeah, I'm so sorry.
Cash
I have
flow.
completely. Oh yes, I'm sorry. This is correct. I'm so sorry, Lords. I'm getting muddled with the electronic version and the hard copy version.
This is the cash flow.
This is the cash flow agreement, and there's no dispute between the parties that this contract was entered into. And there is a separate ground of appeal, which, as I indicated a moment ago, I don't propose to say any more about than is already in the appellant's written case, which is on the basis that the arbitrator found that CCE had wished to terminate this agreement, but that was something MSC had never acceded to. And therefore, there was on the face of it a breach of this agreement, but the arbitrator found that somehow, and this is putting aside the question of appeals on law or fact, we would say a perverse decision in fact, that there was no breach on the part of CCE. As I said, that is a separate ground of appeal. It's dealt with in the appellant's case, and I don't propose to say any more about it. But I mention it at this point because it is relied upon by CCE as a further variation to the contract or modification of the contract, because the nature of the agreement is that sums are to be paid at certain times by MSC to CCE, rather than that sums are to be paid on an interim basis through the operation of the interim certificate or valuation provisions that I looked at with your lordships earlier. And that is relied upon apparently as one of the further elements of conduct which is said to amount to an alteration of the contract from a lump sum to a measure and value type contract. And I address it simply to say that that submission is, with respect, completely misconceived. There is nothing in that agreement to pay fixed sums of money at fixed times, rather than to pay against interim certificates or valuations that could conceivably evidence conduct which varied the nature of the contract from lump sum to measure and value. So those are the four matters that are now relied upon as CC as the conduct. And you've heard what I have said and my learned friends have said about the restriction of the appeal to matters of fact or law, if which plainly we do not accept, the appeal is belatedly limited to one of law, a decision based on, well, I'm sorry, I'm jumping ahead of myself, the arbitrator's decision as to the variation or alteration of the contract from lump sum to measure and value relied in my submission solely on the payment of the interim certificates, which is the matter that I've addressed. I accept that he makes reference to the absence of an architect in certain circumstances, but that is not on the face of the award one of the matters that he relies upon as evidencing an agreement to change the nature of the contract. Even if it were, in my submission it doesn't, and I've addressed that already. And the other two matters now relied upon by CC as evidencing that change in the nature of the contract are the changes in the scope of the work, which I've addressed, and the financing agreement, which I have just addressed, neither of which, in my submission, evidence any sort of agreement to change the nature of the contract. So if, in respect of some of those matters, there is, I hesitate to put it quite this way, but there is almost an appeal on fact by CCE seeking to rely on matters that were not relied upon in the arbitrator's award. Even if one disregards that point, there is nothing in the matters that they rely upon that would evidence such a change in the nature of the contract. The remaining two matters that fell to me to deal with were the claim in respect of the mechanical and electrical works, which I've already addressed this morning. The short point is that the arbitrator's award at paragraph 7.11.1 makes a clear finding that CC departed from the terms of the contract in respect of the design, the quality of the design of the mechanical and electrical works. But despite having found that breach, he then concludes that my client's MSc somehow, his term is accepted, which doesn't really fit with English jurisprudence, but accepted that breach in the sense that they waived any claim for damages. There is, it's dealt with in the written submissions, no evidence on which that conclusion could have been reached. And therefore, whilst I accept that that is...
Let's just look at the paragraph.
Yes.
You're quarrelling with the phrase MSc can be said to have accepted
yes.
the departure.
Exactly. And where that leads to as a conclusion is that there is therefore no claim for damages for breach.
Well, didn't they accept the departure because MSc decided to subcontract the CDP works?
Well, there are two elements, my Lord, to the works that fall under that heading. There is the design element and there is the installation element. And what happened was that, and this is, I think, not as such disputed, was that MSc in due course engaged engineers called Pro 5 to carry out the design and subcontractors to carry out the installation. And the inference, I generously call it that, of the arbitrator was that somehow that was an agreement to draw a line under the breach of CCE, its departure from the terms of the contract. Lords, I apologise if I haven't made it clear. It's addressed in the written case, obviously, but the departure is not designing in accordance with the terms of the contract. And those terms require the design to be carried out with reasonable care and skill, which in this case would have included, no one I think disputed, carrying out the design in accordance with the relevant Mauritian standards. And CCE, a Chinese contractor, produced designs, but they did not accord with the Mauritian standards. And that is not in dispute, at least that is recorded on the face of the arbitrator's award. The issue that I therefore take with the accepted the breach terminology is that what that appears to mean, well, it does mean, because the claim for damages is then rejected, is that MSC, by giving that design to someone else, was saying, if I can put it rather colloquially, it's all right, CC, don't worry that you've got it wrong and you're in breach of contract. We're going to get someone else to do it and not make any claim against you. That is hugely improbable, and there is not a shred of evidence that it's what happened, and no such evidence is recorded by the arbitrator.
What were you claiming by way of damages?
I'm sorry, my lord.
What were you claiming by way of damages?
We were claiming the costs of having the works designed by another engineer.
So, but you couldn't claim the whole cost because there was presumably a saving element. You didn't have to pay.
No, that comes back, I'm afraid, to where we started with the lump sum. Because if you have the lump sum, and included within the lump sum is the cost of design work, and then you have a claim for damages, you simply set it against the lump sum, and that will mathematically take account of the amount that you should have paid because it's in the lump sum, and the amount that you have deducted in a perfectly.
Are you saying it's part of the 12 million? The difference?
No.
Well, where does it come in? That schedule that we were looking at.
Well, it isn't there. There's nothing in that schedule that expressly deals with design.
Yes, well then you haven't been charged with it. I thought you were saying that you had been charged with it.
No, I'm answering the Lordship's question as to how one deals with it contractually.
Yes, but my question was, what's the damage if, you haven't had to pay for it? And I think you were saying that you did have to pay for it because it's in the lump sum. Can we?
Well, I apologise for saying this, but it's sort of putting the cart before the horse. Because if one assumes that there's a lump sum contract, it's for, I'll make it $1 million to make it simpler. And within that is the cost of designing something. And the contractor doesn't carry out the design. One doesn't need to know within the lump sum what part of that $1 million relates to the design, because it's in the lump sum. If he doesn't do it and you end up spending...
it should be removed from the lump sum.
No. You don't remove it, you add it as, you don't add it, you set it off and counterclaim it as a claim for damages. You don't have to take it out and then, because it's a breach, not an omission. That's, I'm sorry, my lord, I probably didn't have your lordship's point.
I'm surprised that it's not I mean, if it had been a variation, if there had been an agreed...
If it had been a variation, that would have been a different matter, but it wasn't a variation. This was the case of the contractor failing to comply with its contractual obligations as recorded by the arbitrator. And there should, in my submission, then have been a claim for damages which would simply have been set against the lump sum. So one would never get into the question of how much was in the lump sum for design, and you don't know how much is in the lump sum for design on the face of the contract because it doesn't say.
Yes, I see.
And the provisional sum items that are referred to by CC expressly refer to installation and not to design. So you'd simply have had a very standard contract sum and set off for damages.
If you're right that in fact the arbitrator has not operated on a lump sum basis but has operated on a measure and value basis, then he can't have measured or valued this design work because it wasn't done by CCE.
Indeed, but if it then cost my clients more to have it carried out by somebody else than they would have paid for it within the lump sum, they have suffered a loss.
Yes, but you ought to be claiming any difference, and you haven't identified the difference.
My lord, I entirely accept that that's right if the contract is a measure and value contract, but it's where it simply...
You're saying... I see.
It simply compounds the problem.
If we're looking under this head solely at the cost of design, what are we talking about financially?
I have a feeling that the figure is about...
5 million, isn't it?
Well, it's 8 million. I think it was identified in your grounds of appeal.
Ah, thank you. I'm grateful, my lord.
Notice of appeal, item 4, which claim for 8 million odd rupees.
Yes.
The damages arising out of respondent's failure to carry out the ME works. a further 400 falling away.
But was that does that 8 million only cover the design cost, or does it also relate to delay in the M&E work? I mean,
Yes.
what are we talking about here?
Can I answer that question at 2 o'clock when I've had a chance to look it up and find the correct reference?
And
And I promise to take no more than 30 seconds to do so.
what about, is there anything more to be said on financing
My lord,
or loss? In respect?
I don't, having regard to the respondent's case on this, there's nothing, I think, unless your lordships have any questions, that I think I can helpfully add to the appellant's written case.
I see. Right. Well, thank you very much. Let us resume at 2 o'clock.
And I shall answer the question. Thank you.